So, how does a guardian ad litem work in a divorce case involving children? That's what we're going to talk about right now. My name is Bobby Buchanan. I'm the host of Illinois Divorce TV. I'm also a practicing divorce attorney in the Chicagoland area. Now, let's dive in. We're going to go straight to the whiteboard here, and I'm going to show you the actual statute that provides for the appointment of a guardian ad litem. Now, what does guardian ad litem mean? Or GAL. You might hear the term GAL. Some people say GAL, but really the common vernacular is guardian ad litem or GAL. What a GAL is the eyes and the ears of the court and an attorney that represents the best interests of the child. So if we go down to the statute here, we can look here and see that in any proceeding involving support, custody, visitation, allocation of parental responsibilities, the court can appoint a guardian ad litem. Now, the guardian ad litem is the shall, not may or is, shall testify or submit a written report to the court regarding his or her recommendations in accordance with the best interests of the child. So that really sums it up there. It's an attorney that is tasked with the responsibility to give a recommendation to the court as to what is in the best interest of the child. So a guardian ad litem is appointed by a judge upon a motion by either party or the court's own motion, meaning the judge could just say, you know what, we need a guardian ad litem. Now, when can a guardian ad litem be appointed? If we say that this circle here is the filing of a case, so the beginning, and this is trial, meaning the end of the case, trial, sorry, you can't read that too well, and then we'll call this appeal. So this is after the trial. When can a guardian ad litem be appointed? A guardian ad litem could be appointed here, anytime. The appellate court can actually send the case back and say that a guardian ad litem should be appointed or recommend to the court that they appoint a guardian ad litem. And what you can expect when a guardian ad litem is appointed is first, the guardian ad litem is going to ask your attorney for permission to speak with you outside of their presence. And this is always given. In 99.9% of cases, the attorney is going to say, yes, you can speak to my client outside of my presence. The next thing that will happen is that they'll schedule a interview with you, and usually you'll go to their office and they'll interview you, and there's no set interview that they have to do. They can come up with it using their years of experience or research or whatever they feel is the best way to conduct their investigation. Depending on the age of the children and who has possession of the children, they may also ask you to bring the children in. They may decide that they want to see the children in their native environment and request to go to your house. Depending on the issues involved, they may have requests of you to, say, take a drug test, or they may want to come over to your house to just watch and kind of investigate the house and see what it looks like, so they can report back to the court exactly what the house looks like, how the children behave in the house, how you interact with the children in the house. If there's mental health issues or medical issues, they can ask that you sign releases. And those, asking for you to sign a release, it's somewhat of a request and it's somewhat of an obligation, because if you don't sign a release, that is going to lead to more questioning, and if they can't get at certain information, that may flip their recommendation one way or the other. But the basics of it is, it's an attorney that wants the case to settle ultimately, but they also want to make sure that the best interest of the child or children is looked out for. And when they are involved in the case, there's going to be at every court date an opportunity for them. They will appear at every court date, except for the ones that involve just purely financial issues. They may be excused for those, but they'll appear at most court dates and be expected to give some sort of report to the judge as to what's going on with their investigation, if there's any roadblocks in their investigation, and then the judge may issue orders facilitating that investigation. The first kind of big effect big influence that the guardian ad litem is going to have is during their first significant oral report. And that may be done in a pretrial conference. A pretrial is an in-chambers conference that is off the record, if you will, just with the attorneys and the guardian ad litem, and they will tell the judge what they found in their investigation and what their recommendation is. Can you change guardian ad litems? No, you can't change guardian ad litems. Who pays for the guardian ad litem? Generally speaking, both parties. And at the beginning of a case, if incomes are substantially similar, or it looks like both parties can't afford, or if it looks like both parties can equally not afford a guardian ad litem, it'll be split. And it's usually subject to reallocation, meaning the judge can come back later and say, you know what, that initial split of the guardian ad litem's fee doesn't make sense in this case, so we're going to make dad pay 75% and mom pay 25%. Usually there's a retainer when they're appointed, so the court will say the guardian ad litem needs a $3,000 retainer. It's going to be split between the parties. They both have 14 days to pay the guardian ad litem $1,500. Sometimes you can work out a payment plan with the guardian ad litem's office if you don't have the full $1,500. Will the guardian ad litem recommend or change their recommendation based on who has paid them? Well, certainly they shouldn't. Certainly that would be unethical unless your non-payment of the guardian ad litem is indicative of broader financial issues that are directly affecting the child. But just you paying or not paying the guardian ad litem is not going to have any direct bearing on the recommendation of the guardian ad litem, or the court can't weigh that as evidence as to whether or not you should get more or less custody in a case. But certainly not paying them isn't a great look, and we're all human, and there are the psychology of influencing people, and if you are not paying, that may have a subconscious effect as far as their recommendation. I'm trying to think if there's anything else. That's all for now. If you have any other comments, questions, concerns about guardian ad litem, I'm sure this isn't going to be my last video on this subject, but drop your comments and everything else in the comment box below, and I'll talk to you soon. Have a great day.